So that's their double speak gaslighting bullshit. And then they filed a motion to dismiss. Motion dismissed is really long. It's 32 pages. That'll take us about 9,000 years to get through. Okay. In this, they make their same arguments again. That FINRA is a self-regulatory organization, conducts data regulation, national securities pursuant to the authority granted by Congress and with oversight from the SEC. Doesn't issue, cancel, settle, clear securities traded, blah, 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 blah. It just happens to help their buddies. Plaintiff alleges antitrust securities law violations in support of her request for equitable relief. The request for relief, however, seeks to prevent or delay company-related action by a party not before the court, which FINRA understands has already occurred. So FINRA is saying, hey man, we only regulate trading stock, and this stock doesn't trade anymore, therefore we can't regulate it. But it doesn't trade anymore because you stopped trading it. So they're going to do more double speak here. And then they're going to say absolute immunity 5,000 times in a row. In the next break prospectus, Meta described two terms of the company-related action that are relevant in this case. Meta would cancel for shares. No, deleted, not canceled. And Meta would release its shares of NextBridge common stock to be distributed to shareholders of the Series A shares on a one-to-one basis, which they did, but it can't be distributed because you halted trading. It's been his understanding that Meta company action occurred on December 14th. Yes. They did send out the shares December 14th, but because no short shares were closed, no one's gotten their friggin' shares. Okay. Indeed, plaintiff initiated this case after FINRA exercised the regulatory authority December 9th to direct its members to halt trading and quoting of Series A shares. On December 13th, 2022, the trading halt ended concurrently with FINRA's deletion of the MMTLP symbol. FINRA has not deleted the MMTLP symbol. They have not done it yet. It has not happened. They've not deleted anything. Nothing has been deleted. There has been no D1 order deleting any of the MMTLP symbols from their system. That has not happened yet. So right here, in their motion to dismiss, they just lied to the court. Okay. Plaintiff's complaint, which is replete with vague and conclusionary allegations, is so vague that she points out exactly how many short shares FINRA says exist. Right? She shows us our own FTD data. I don't know why she was so vague. Cannot overcome FINRA's absolute immunity. They do not have absolute immunity. How many times the client state this? They have immunity to monetary damages. That's it. That's all they have immunity to, is monetary damages. They can be sued. They have been sued many, many times. When it gets thrown out is when people are looking for monetary damages. When it's successful is when they're not looking for monetary damages, such as inaccurate accounting or to bring back the 2 days of trading that we were promised. Okay. Court's analysis of the motion need not go beyond considering FINRA's absolute immunity. Again, using the absolute immunity thing. First, this court lacks subject matter jurisdiction of plaintiff's case because the case is now moot because plaintiff failed to establish she has Article 3 standing. So if you know what Article 3 standing is, so Article 3 of the Constitution establishes the courts. There's Article 1 courts, which is bankruptcy courts. Those are different than Article 3. Article 3 is the federal court system, essentially saying Supreme Court and any other courts that happen to fall under them. Okay. So basically they're saying she can't bring this to an Article 3 court because absolute immunity. Again. Second, if the complaint could overcome these deficiencies, plaintiff's complaint would warrant dismissal because plaintiff failed to state a claim for relief under the Sherman Act or the Exchange Act. She literally did. She went to both. She explicitly showed how they apply to her case and that the court should consider this because of those reasons. So they're gaslighting again and saying she never showed this stuff when she literally did. Sherman Act claim is precluded because FINRA's decision to halt trading is a regulatory function authorized by the Exchange Act. An application of antitrust laws to this activity would be clearly incompatible. Oh my God, there's so much fucking doublespeak in this. She shows that in the Sherman Act and Exchange Act, that FINRA was acting in a violation of antitrust laws and therefore helping their buddies screw us over. And as a result, can be sued because of that. Plaintiff's Exchange Act claim suffers from similar fatal flaws. Specifically, in the Private Securities Litigation Reform Act, Congress explicitly vested authority to pursue actions for aiding and abetting securities fraud exclusively in the SEC, not in private parties. So are they admitting that they committed fraud in this then? Your Honor, I may have committed all the fraud we want, but she can't do anything about it, right? Finally, neither the Exchange Act nor any other federal statutes gives the rise to private right of action against SROs for actual omissions in connection with their duties as security regulator. Unless those actions as security regulator were erroneous themselves, which they don't note. For reasons plaintiff complaint should be dismissed with prejudice. Factual background. FINRA's role regulating securities industry. Blah, 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 blah. FINRA created blah, 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 blah. Among regulatory obligations, the Exchange Act requires FINRA to establish rules designed to prevent fraudulent and manipulative acts and practices, to promote just and equitable principles of trade, to foster cooperation, coordination with persons engaged in regulating, clearing, settling, processing information with respect to and facilitating transactions, securities, and in general to protect investors and the public interest. U.S. Code, blah, 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 blah. So, it's designed to prevent fraudulent and manipulative acts and practices. Then why didn't they prevent the fraudulent, manipulative actions of the short sellers of Torchlight and MTLP? Right there in the first sentence of their counter mission statement. They didn't do their job. Okay, to promote just and equitable principles of trade. If they want to promote just and equitable principles of trade, why didn't they force close the short positions before the company went private? Two flaws right there in their mission statement. To foster cooperation and coordination with persons engaged in regulating, blah, 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 blah. Okay. They did basically racketeer and collude with those engaged in regulating, clearing, settling, processing. And in general, to protect investors and the public interest. This is where she was showing that she was harmed. And that they didn't protect her, they harmed her by not allowing the continued trading. So throwing up there, like, look at us, this is our mission statement, Your Honor, we do really good works. This is like when Google's mission statement was like, do no evil, and then became a giant monopoly taking over other companies, right? That they like clearly have engaged in evil. Like, Your Honor, our protocol said do no evil, so therefore we obviously can't be doing any evil. Just because your mission statement states one thing doesn't mean you actually follow it, right? Especially if your entire board is made up of insiders at the people you're supposed to be regulating. This problem with self-regulatory agencies is that they shouldn't fucking exist in the first place. It should just be a bunch of stone cold bureaucrats who aren't allowed to work in the financial industry, who are type A's and just want to see everybody burn. That should be who does it. It's not like let's say you're a career criminal, right? Like you rob, cheat, steal, rape, maim, do whatever. And then you take a new job as a police officer. Where you're like, okay, my job now is to regulate all the criminals out there. I'm going to be a really honest cop because the side of my car says protect and serve. You see, Honor, I'm just a self-regulatory agency. And, even though in 2 years I'm going to go back to committing all my crimes again, you can trust me, officer, Your Honor. Okay. FINRA is subject to significant oversight by the SEC. Okay. First of all, it's the biggest joke in the entire world because the SEC doesn't do shit, and we know it, right? The Madoff documentary on Netflix is a great example of showing the SEC does not know how to regulate properly. FINRA exercises regulatory authority in accordance with the requirements of the Exchange Act and under close supervision of the SEC. Really? Under close supervision of the SEC? Then SEC approved the S1, right? The SEC approved MMTLP's action to become a private company, and you overstepped that with your own bullshit. So you overstepped what the SEC said was going to happen, and so you disobeyed the SEC. SEC enforces FINRA's regulation of the OTC market. Pursuant to authority delegated under Exchange Act, FINRA performs several regulatory functions in the OTC market, including, among others, maintaining a symbols directory for OTC equity securities and adopting rules regarding quoting and trading in OTC securities. FINRA rules and amendments thereto that are relevant to issues presented in this case were approved by the SEC. Yep. And they also approved the S1, ding-dongs. Okay. Rule 6440, trading and halting OTC equity stocks. Rule 6440 authorizes FINRA to direct its members to halt trading and quoting in an OTC security when it is necessary to protect investors and public interest, including where FINRA determines that an extraordinary event has occurred or is ongoing that has caused or has the potential to cause major disruptions in the marketplace or significant uncertainty in the settlement and clearance process. Okay. Remember, uncertainty in the settlement or clearance process. They claimed that if anybody opened new positions on the 9th or 12th of December in the stock, it would provide uncertainty in clearing, and that's why they had to halt trading. But because they halted trading and brokers weren't able to force close positions, short positions, before end of trading on the 12th, there has been nothing but uncertainty in the clearing and settlement of the Nexbridge shares. So the distribution cannot happen because of the actions you took claiming it you had to take because this was going to happen. This is like a dude who sets a house on fire and then calls the ambulance or the fire company to come put it out and then wants to be called a hero for getting the house fire put out. Like, you caused this, dude. Hey, cat. It's so much fucking double speak. Okay. In announcing the rule change approved by SEC, explained it would exercise its discretion based on the facts and circumstances of a particular event to determine if a trading halt is the appropriate mechanism to protect investors and ensure fair and orderly marketplace. So basically, they're saying, like, we have the delegation, we've been delegated this authority as long as we use it to protect investors. But Rose's lawsuit is showing that their action harmed investors. Therefore, they didn't use their delegated authority properly. But they're still trying to claim that we did the right thing, Your Honor, even though we kind of admitted that we broke the rules, that SEC should be busting us for it and not her. Rule 6490 codifies requirements for issuers of a class of publicly traded securities to provide a timely notice to FINRA of certain company-related actions. You became aware of this in July. You had 6 months, dude. 6 months. They gave you notice after notice after notice after notice after it was approved by the SEC on November 16th or whatever. They sent you a request for corporate action, and you spent more than 3 weeks dicking around, not doing anything before you released your corporate action. So requires issuers of publicly traded securities to provide a timely notice to FINRA of certain company-related actions. They did. You just didn't do your job. All right? FINRA processed documentation of company-related action. They provided ample time. And you took your sweet time to issue a 2-sentence corporate action that you fudged up and had to re-edit because you used the term canceled instead of deleted. And then 12 hours later, had a panic attack and canceled trading. FINRA does not approve a company-related action submitted pursuant to blah, blah, blah. FINRA reviews documents submitted in its connection with company-related action, and if the documents are not deemed deficient, FINRA processes a request and provides notice of the company-related action through announcement in the FINRA daily list publication, which you took 3 weeks to do. All right. And then you posted with the wrong term. Okay. The next prospectus, which attached as Exhibit B to plaintiff's complaint, describes Meta company action. Prospectus says NextBridge was a wholly owned subsidiary of Meta. Meta held all the common stock issued by NextBridge. The prospectus provides that on the distribution date set by Meta, Meta would release the NextBridge shares to a distribution agent that would distribute the NextBridge shares in book entry form, and Meta would cancel Series A shares. The prospectus further explains that each holder of Series A shares, December 12th, data record set by Meta, would be entitled to receive one NextBridge share for each Series A share. According to the prospectus, following the Meta company action, NextBridge would be an independent, non-trading public reporting company. Only until December 31st of 2022, and after that as a private company. Meta submitted a request to FINRA pursuant to FINRA Rule 6490 to process documentation Meta company action. On December 6th, as modified December 8th, for announced Meta company action, a share exchange on the daily list publication, announcement, blah, blah, blah. Announcement explained MMTLP shareholders with settled positions as of December 12th will receive one NextBridge share. Among other things, the announced further explained that any purchases of MMTLP executed after December 8th would not receive distribution. Notice the the ellipses here, the that they put in, right? The next words were settlement would be the obligation of the seller. So they're leaving out the part of this that explains why trading would be able to continue for 2 more days. They're omitting very important facts of law here to the court. This ellipses of 4 dots, it should be 3, is very, 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 very what would be the term I'm looking for here, monkey dog? Carry a lot of weight. Very important. Quite the omission. Will not receive distribution, but if you continue to trade after this date, settlement would have to be done by the seller. Okay. Meta company action was finalized December 14th when they issued the NextBridge shares. The trading halt. December 9th, FINRA exercises authority under FINRA Rule 6440 to direct its members to halt trading and quoting in Series A shares because an extraordinary event has occurred or is ongoing that has caused or has the potential to cause significant uncertainty in the settlement and clearing process of shares. So going through their little rule again. As announced, the trading halt ended concurrent with the deletion of MMTLP symbol effective Tuesday, December 13th, 2022. You can go to FINRA's website and look for the order to delete the MMTLP symbol, and you will find they have never issued the order to delete that symbol. No D1 order has ever been done. So again, here is FINRA lying to the judge. Standards review. To survive a motion to dismiss or lack of subject matter jurisdiction, complaint must plausibly allege facts showing jurisdiction over the plaintiff's blah, 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 blah. Claims. As part of this requirement, plaintiff must set forth plausible allegations to establish each element of standing under Article 3 of the Constitution. And to survive motion to dismiss for failure to state claim, a complaint must contain sufficient factual allegations to state a claim to relief that is plausible on its face. Bare legal conclusions are insufficient. Basically, they're saying, again, they're gaslighting the judge again, saying that Rosa never actually showed how she was harmed or evidence that FINRA acted poorly or did their job inappropriately, even though she did it several times. Argument. Absolute immunity bars plaintiff's complaints. They don't have absolute immunity. Imposition of a halt that suspends trading is a quintessential regulatory function. It is a quintessential regulatory function, but one that you abused. That's her entire her entire case. Okay. They're just going to do this over and over and over again. And talk about immunity, the same arguments they made over and over again. So there's really nothing new in this motion to dismiss thing. We can probably just, do a little jerk off motion and assume Rosa will address this quite handily. They still have until the 1st to respond to her initial complaint, which is next Wednesday. And that response is likely going to have to be piece by piece through the entire complaint, which is 202 pages. So I'm curious to see what it is that they get in here. Okay. All right. So they're just doing the same arguments they did over and over again. We'll just save you guys this guy. And just know that there you go. Okay.